Breaking. Court summons Bola Ahmed Tinubu, Akpabio and others over River State emergency rule. Hello viewers and welcome to InfoGist TV. A federal high court in Port Harcourt has issued a summons to President Bola Ahmed Tinubu and 7 others regarding the declaration of a state of emergency in River State. The others named in the suit include the President of the Senate, Godswill Akpabio, the Speaker of the House of Representatives, Tajuddin Abbas, the National Assembly and the Attorney General of the Federation. Also joined in the suit are the Rivers Sole Administrator, Vice Admiral Ibokete Ibas, the Revenue and Fiscal Mobilization Commission, and the Central Bank of Nigeria, according to the News Agency of Nigeria. The case filed under suit number FHC PHC CS 45/2025 was brought by the Incorporated Trustees of People's Life Improvement Foundation, Precious Elikema, and Inanna Wright Harry. The plaintiffs are challenging the legality of the emergency declaration and seeking the court's interpretation of its constitutionality. Among the key questions raised is whether President Bola Ahmed Tinubu's declaration of a state of emergency in Rivers State on March 18, 2025 is unconstitutional, null and void. The plaintiffs argue that the move constitutes a breach of Articles 13 of the African Charter on Human and People's Rights Ratification and Enforcement Act and Sections 305 sub 3b of the Constitution of the Federal Republic of Nigeria 1999 as amended. They are also seeking a court order restraining the River State Administrator from appointing caretaker committee for the 23 local government councils, forming a state executive council, awarding contracts or making any financial transactions from the state's treasury. Additionally, the plaintiffs are demanding the restoration of democracy in River State by reinstating the suspended executive and legislative arms of government. Furthermore, they are asking the court to issue a perpetual injunction restraining the president from further suspending democratically elected officials in the state. The court has given the defendants 30 days to respond to the summons. It warned that failure to respond could result in the case proceedings. In their absence, the legal action was filed by Ebere Aru Uguja, Esquire, on behalf of the plaintiffs. Recall that the Federal High Court sitting in Abuja has been asked to sack the recently appointed sole administrator of River State, Vice Admiral Ibokete Abbas, retired, while President Bola Ahmed Tinubu was cited as the first defendant. The Attorney General of the Federation, Vice Admiral Ibas, retired, and the Attorney General of the 36 states of the Federation were listed as second to 39 defendants in the suit marked FHC ABJCS 572/2025, which was lodged before the court on Tuesday. The suit, which was filed by an Abuja-based legal practitioner, Mr. John Mary Jidobi, is equally praying the court to set aside as void all actions and decisions, howsoever described or made, of the third defendant, Vice Admiral Ibokete Ibas, retired, in the name of sole administrator of River State, same being unconstitutional, null, and of no constitutional force throughout the Federal Republic of Nigeria for all purposes. The plaintiff further prayed the court to issue a perpetual order of injunction restraining the first defendant, Tinubu, either by himself, his officers, agents, previous servants, or any other person acting under his command, however named, from either removing, suspending, or otherwise tampering with the tenure of the governor and deputy governor of River State, and indeed any other state in Nigeria, as well as an order of perpetual injunction barring President Tinubu, either by himself, his officers, agents, previous servants, or any other person acting under his command, however named, from appointing any sole administrator into any state government house in the 36 states of the Federation for any purpose whatsoever. In the originating summons, he filed through a consortium of lawyers led by Mr. Chimezie Enuka. The plaintiff prayed the court to determine whether, in the view of the combined provisions of the entirety of sections 1/5 sub 2, 180, 188, 189, 305, and 306 of the 1999 Constitution of the Federal Republic of Nigeria as amended, and their conflated interpretations, the President of the Federal Republic of Nigeria, being the first defendant herein, has any constitutional authority whatsoever to either remove, suspend, or otherwise tamper with the tenure of the duly elected governor and deputy governor of River State, and indeed of any other state in Nigeria, and appoint a sole administrator or any other substitute howsoever called or described, such as the third defendant for that state. Upon the determination of the question, he prayed the court declare that upon an intimate reading and complete understanding of the entirety of sections 305 of the 1999 Constitution as amended, there is no other circumstances contemplated by the Constitution for the removal or interpretation of the tenure of an elected governor and deputy governor of a state, except the circumstances contemplated under sections 180, 188, 189, and 306 of the 1999 Constitution of the Federal Republic of Nigeria as amended. A declaration of this honorable court that, in view
of the entirety of sections 1, 5 sub 2, 180, 188, 189, 305, 306 of the 1999 Constitution of the Federal Republic of Nigeria as amended. The President of the Federal Republic of Nigeria has no constitutional authority to either remove, suspend, or otherwise tamper with the tenure of a duly elected governor and a deputy governor of a state, and appoint a sole administrator or any other substitute howsoever called or described, such as the third defendant herein for that state. A declaration of this honorable court that the purported suspension of the governor and the deputy governor of Rivers State of Nigeria by the first defendant on Tuesday, the 18th day of March 2025, is unconstitutional, null and void, and of no legal effect whatsoever. A declaration of this honorable court that the purported nomination, appointment, and swearing in of Vice Admiral Ibokete Ibas retired by the first defendant as the sole administrator of Rivers State of Nigeria is unconstitutional, null and void, and of no legal effect whatsoever.
And an order of this honorable court setting aside the suspension of the governor and the deputy governor of Rivers State of Nigeria by the first defendant on Tuesday, the 18th day of March 2025, for being unconstitutional, null and void, and of no legal effect whatsoever. An order of this honorable court setting aside the nomination, appointment, and swearing in of Vice Admiral Bokete Ibas, retired as the sole administrator of Rivers State of Nigeria by the first defendant. Likewise, an order of this honorable court directing Vice Admiral Bokete Ibas, retired, the third defendant herein, to vacate forthwith the government house of Rivers State of Nigeria. In a 32 paragraphs affidavit he deposed in support of the suit, the plaintiff maintained that though President Tinubu has the constitutional power to declare a state of emergency in deserving circumstances in any part of the federation, he does not have the power to suspend elected officials like a governor who is not his appointee. As a Nigerian lawyer and all through my years of practice, I have never seen the word sole administrator in the amended 1999 Constitution of the Federal Republic of Nigeria. I know that neither the first defendant nor the second defendant appointed the governor and deputy governor of Rivers State of Nigeria, and that no governor or deputy governor in Nigeria is an appointee of the first and second defendants. I know that Nigerian practices federalism hinged on separation of powers. I have instituted this suit in the public interest, in the defense of the rule of law, and in accentuation of the supremacy of the Constitution, and to preserve the integrity of the Nigerian Constitution, which is the most sacred document that holds the Nigerian state in balance and in being. I am genuinely worried that, in the absence of the intervention of this court, the removal of duly elected governors and deputy governors may become the pastime of the president, thereby opening the floodgate of anarchy capable of consuming this nation. It will be in the best interest of justice for this honorable court to grant the prayers contained on the face of the originating summons. The plaintiffs averred